This court should vacate or reverse the circuit court's judgment on either of two independent grounds. First, Bright's challenge to the temporary suspension of his FOID card is moot because his FOID card was reinstated in May 2023, and he did not make a clear showing that any mootness exception applies. Federal courts of appeals have issued several decisions that have uniformly upheld a similar federal law that prohibits the acquisition of firearms while an individual is under felony indictment. So those cases provide clear guidance to lower courts in Illinois, specifically as to the historical tradition allowing for the complete but temporary disarmament of individuals facing felony charges. Surety laws that allowed for restriction of firearm access to those reasonably accused of intending to breach the peace, and those could be entered on a finding of probable suspicion that an offense was intended, similar to the probable cause determination that accompanies felony charges.
My client is a nonviolent person. He is a genuinely innocent man who was genuinely falsely arrested and genuinely violated of his constitutional rights. What we're challenging is the fact that they are deprived of the use of arms simply because ipso facto they are charged with a felony, any felony, no matter what the felony is, no matter what the evidence is. It's a total ban based on mere accusation. And there is no, other than the fact that yes, you could lock somebody up, and the king did lock people up. That was one of the crimes of the listed in the Bill of Rights, potentially indefinitely. That's why we have a speedy trial clause of our Constitution. Technically, it is moot, but there are exceptions to the mootness doctrine that apply that allow this case to proceed.
Does it come within the public interest exception?
All right. Why does this come with
how?
How? One, it's a matter of public interest. Constitutional rights are a matter of public interest. This is a state statute that is being enforced by the Illinois State Police that regulates a fundamental constitutional right. This is a matter that reoccurs routinely. This is actually the second time this issue has been in front of this court in the last couple of years.
So your argument really is that the statute is facially unconstitutional because it does not provide for individualized assessment of the defendant's dangerousness.
As applied through 922N, I agree with that, but there are other statutes that can be applied through Section 8N that do allow for individualized assessment, such as the mental health determination. But again, there is no historical analog to simply saying, I accuse you of a crime, therefore you cannot keep and bear arms.